Here are some common misconceptions about copyright law. If you give the creator credit, then you're good. Wrong. Because if it's on like SoundCloud, you can just download it and use it. Wrong. If you manage to trick the YouTube bot into not realizing that you've used copyrighted material, then you're good. Wrong, wrong, wrong. Hi there, my name's Leja. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. Today I want to talk to you about copyrights. Mainly I want to tell you how not to get sued for using someone else's copyrighted material. If you're a YouTuber or creator of any sort and you use stuff that someone else created, you might be infringing copyright laws. Want to learn more? Stay tuned! Let me first offer the following disclaimer, and that is that I am a lawyer, but I am not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions. I'm just here to tell you a few facts. Okay, so let's start with the real basics. What is a copyright? So a copyright is any original work of authorship fixed on a tangible medium. That's how the copyright law describes it. Basically, literary works, artistic works, music, even sometimes computer code, these are all copyrightable works because they're original to the author and then they're fixed on a tangible medium. Tangible medium includes when you type words into your computer on Word, for example. When you type that in, that's fixed on a tangible medium. It's a digital medium, but for the purposes of the law, it's considered tangible. With music, you have both the creation of the music itself, so the melody and the lyrics, but you also have the recording of the music, so the actual physical audio recording, and then you also have performance rights. So the performance of the song is its own copyright. So those are three separate copyrights in one piece of original authorship. So anything original that someone's created and put down on paper or put into reality somehow, usually copyrightable. How are copyrights formed? You don't have to register with the federal government. You don't have to submit anything. Copyrights are formed the second that the work is created. So the second that you put those words onto paper, you put that paint onto the painting, you snap that photo, you are now the copyright owner of the work that you've created. You have copyrights. You don't have to do anything else. Your copyrights are created the second that you create. The reason why the law is this way is because as a society, we've decided we want to award creative people, people who innovate, people who make things. We want to encourage them to be creative for the good of society, and in return, they get a monopoly over the things that they've created, meaning they get to control how that creation goes out into the world. Specifically, your copyright gives you the right to reproduce what you've made or make copies of it, perform what you've made if it's performable, or display it in some way, license the use of your creation so you can tell someone else that they're allowed to use it. You have the right to give them that license or to not give them that license. And you have the right to create derivative works from your creation and to prevent others from doing so. Derivative works meaning something created based on the original work. So once you make that creation, you have this copyright in it. That copyright lasts for your entire life plus 90 years after you die. And again, we're giving that to creators because we want to incentivize people to create, because once you create something, you have ownership over it for a really, really, really long time. So that's great for creators, but what that means is that if you want to use art from someone else, there's a high possibility that someone has copyrights in that work. After that life plus 90 years protection ends, the creative work enters what's known as the public domain, meaning that it is for everyone in the public to use. The reason we do that is because while we want to reward creators, we want to eventually allow their creations to be used and enjoyed by everyone. Now, the copyright law has been amended and changed a bunch over the years, but for right now at least, anything that was created before 1924 is part of the public domain. With the caveat, though, that you'll remember that I said that music has both the copyright in the sounds and the melody itself, but then also in the performance and in the audio recording of it. So yes, Bach wrote all of his music before 1924. However, if someone last year played one of Bach's songs and someone recorded it, someone's going to have a copyright over the recording, even if there is no copyright over the original underlying work. Even though the song is old, it doesn't necessarily mean that the recording you're listening to is in the public domain. So what I'm saying is recordings before 1924, anything recorded before 1924 is part of the public domain, just like anything painted, any photo, anything like that that was taken before 1924 is going to be in the public domain. So what does this all mean practically? In practice, this means that when you create something, you have rights in it that you are allowed to protect. If someone takes what you've created without your permission, then you have a right to sue them. With the caveat being that if you want to sue, you do have to register your copyright with the federal government. Basically, by doing this, you're proving to the court that you are the actual owner of the work so that you can move forward with a lawsuit. One side note technicality, but the point being that when you create something, you have a right in it. On the flip side though, this means that anything that anyone else has created that you want to use, say music in your YouTube video, photos in your presentation, things like that, you need to get their permission first before you can use it. Meaning you need to get a license from them to use their creation. And license is kind of a scary legal term. License just means permission. This could be as easy as sliding into their DMs and saying, hey, I want to use your photo for X, Y, and Z. Is that okay? And them saying yes. This is not legal advice, but as a general rule of thumb, it's always best to get things in writing. So the more formal you make it, the safer you're probably gonna be. But getting permission is the central concept here. Get permission before you use someone's creation. Here are some common misconceptions about copyright law. If you give the creator credit, then you're good. Wrong. Just because you credit someone when you're using their creation, that does not protect you from the copyright law. You are still committing infringement if you did not get a license or permission. Now, the internet has complicated this a lot because Instagram, for example, technically every time that you share someone else's photo or painting or what have you from their Instagram onto your Instagram through your stories or on the feed, you're technically committing copyright infringement. Unless you explicitly ask them, may I share this? You're technically committing infringement. However, there is this idea that when you're on Instagram, it's kind of assumed that people are going to share what you're sharing. So Instagram has definitely complicated this idea, and the internet generally, of copyright law and what's protected and what the expectation is for when you're posting something on the internet. But all of that aside, just because you're crediting someone does not mean that you are immune from a lawsuit. And in fact, this is becoming a growing problem with celebrities who are taking paparazzi photos and putting them on their Instagram. They're starting to get sued by paparazzi. I made a whole video about this, but they're starting to get sued because paparazzi are realizing this is technically copyright infringement and these celebrities have a bunch of money, so if I sue them, I can win the case pretty easily and get their money. In most cases, however, you're not going to get sued when you share someone else's thing on your Instagram story, partially because lawsuits are really expensive, and a lot of times creators don't have a ton of money and a lawyer on hand to just be suing people left and right for taking their creative work. But just know that when you take someone's work and you share it without permission, you're committing copyright infringement, and crediting them does not fix that. Another common misconception is if it's on like SoundCloud, you can just download it and use it. Wrong. Unless you get their permission, you cannot use it. Period. Similarly with like Spotify, people who are uploading music onto these streaming platforms, they are giving the streaming platforms a license to use their copyrighted work. It's part of the contract you sign that you probably don't even realize you're signing when you upload your music onto these platforms. However, that license does not include things like playing the song to a large group of people, or playing them like over the speakers at a coffee shop, for example, or downloading them illegally and then putting them on the background of your YouTube video, for example. That use is beyond the scope of the license that artists are giving to these platforms. Usually artists are giving the right to these platforms for their users to listen to the music privately. Licenses for public performance of music are separate licenses, and they are not usually included when artists upload their music onto Spotify, for example. So you do not have a license just because it exists on Spotify or SoundCloud to then download the music and put it on your YouTube video or perform it publicly. So if you walk into a restaurant, for example, and they've got music playing over the speakers, technically they need to have purchased a license to do that. There are organizations that sell these types of licenses that are blanket licenses, so you get a whole slew of music that you can choose from and play publicly, but technically you do need a license to play music publicly in a business, for example. Another common misconception, at least here on YouTube, is that if you manage to trick the YouTube bot into not realizing that you've used copyrighted material, then you're good. Wrong. You've still committed copyright infringement if you've taken a song and put it in your video and the bot just didn't pick it up. Or if you've taken copyrighted music and put it in your video and the bot picked it up, but instead of getting a strike, it's just not letting you monetize your video. That's fine if you don't care about monetization, but the fact is that just because you don't care about getting demonetized, you are still committing copyright infringement. So you might feel fine about not getting monetized, but you could still get sued by the copyright holder for using the work in your video, unless you get permission. Again, across the board, rule rule of thumb, always get permission to use someone else's creative work before using it. And I can attest to this as someone who, I was a photographer before I went to law school. It sucks to see your photo pop up on something that you did not give permission for. And it sucks to be a creator who doesn't really understand the law and you don't know what your recourse is. And even if you did know, you probably wouldn't have the money to pay for a lawyer to sue someone. So it sucks to be a creator and have your work used without permission. It also sucks when you can't use whatever art and music you want. I get that too, but you have to understand why this is in place, and you have to respect the fact that if you don't get permission, you can't use copyrighted works. There are a few caveats to this, which I'll go over, but I just wanted to lay out that rule of thumb because there seems to be some common misconception that if you just credit it or you like trick the YouTube bot, then you're free and clear, and that's not how the law works. And this is important because the consequences of a lawsuit for copyright infringement can be really intense. The Copyright Act writes into it that you can get sued for between $750 and $150,000 for every single instance of infringement. So every single song you've downloaded, that's a separate instance of infringement that you could get sued for up to $150,000 in fines. And so if you use someone's copyrighted song in your YouTube video without permission or without a license, you're committing more than one act of copyright infringement. When you download the song from online onto your computer, that's one act of copyright infringement. When you put it in your video and then upload it back onto YouTube, that's a second act of copyright infringement. That's $300,000 worth of potential fines. This ain't child's play, all right? Like, this is important that you need to know this. Now, obviously, there's a lot of copyright holders who are not going to be going around suing every single YouTuber or whatever who uses a song without permission because, again, lawsuits are lengthy. Lawyers cost a lot of money. Sorry. It's just not economically viable to go around suing every single person who like illegally downloads a song. However, I'm sure you've probably heard of cases where companies who own a bunch of copyrights want to make an example of someone, and so they sue some teen who downloaded a bunch of music onto his computer off LimeWire in the early 2000s for hundreds of thousands, if not millions of dollars for copyright infringement, kind of as an example to show other people like, hey, this could happen to you too, so don't download things illegally. Honestly, most people want to avoid lawsuits because lawyers are annoying and expensive. Sorry again. So oftentimes you might just receive what's called a cease and desist letter, which is just going to be a little letter from the lawyer saying, hey, we represent this artist. We know that you infringed on this copyright. This is against federal laws. Take down your infringing work. Don't infringe again. Confirm to us in writing in a week that you've complied with our demands, and we'll let it go. Also a really scary letter to get though. Basically the point being that you want to tread lightly when it comes to copyrights because there are real consequences, and even if they might be few and far between, it's still a very risky thing to do. And there are ways around this that I want to explain to you so that you don't fall into this trap, commit copyright infringement, and then get into a crap ton of trouble. Okay, so as I mentioned before, there's a little carve out in the copyright law called fair use. This allows for you to use other people's copyrighted material in very specific instances. This includes for news, commentary, parody, criticism, or for educational nonprofit purposes. However, there is no clear-cut guideline in the statute as to this is fair use and this is not fair use. It's something that is interpreted by courts, so until you get sued and brought in front of a judge, you're not actually going to know whether what you're doing really constitutes fair use. And there's a 4-factor test that judges use when determining whether the use of a copyrighted work is fair use. One is the purpose and character of the use, so what was the use at issue. 2 is the nature of the copyrighted work. Is it a long movie? Is it a single photograph? What kind of work is it? 3 is the amount of the work used. So if it's a 2-hour movie and the person used 30 seconds of it, that's going to be less substantial than if it's a single photograph and the person used the entire photograph. And then 4th, courts look at the effect of the use on the market or the potential value of the work. So for example, if you've taken an entire movie and put it on YouTube, you've put the movie on YouTube, consumers aren't going to go and then pay money to the actual copyright holder to watch the movie when it's just going to be available for free on YouTube. So you've used the entire work and you've completely ruined the market for that work for the copyright holder. as an example. Whereas if you take a 30-second clip from a movie because you have a comment you want to make about it, that's commentary. It falls under the categories of acceptable fair use. It's a very small portion of the movie, and you're not ruining the market for the movie. In fact, you might actually encourage people to go watch the movie if you've said something provocative or interesting, or you've criticized the movie in some way that's gonna make people want to go watch it. So the effect on the market for the work itself is less in that scenario. Courts also look at whether the use was transformative, meaning did the user of the copyrighted work add anything to it? Did they change it in any way? Did their commentary transform it into a different type of work? So in that example I gave before where you use 30 seconds of a movie, maybe you've added text to that and you've added your face talking about it, or things like that are transformative. So you're transforming it into a different work for the purposes of commentary or criticism or other fair use uses. Courts also look at whether the use of the work was for commercial purposes or for nonprofit, more educational purposes. Obviously, it's going to weigh in your favor if your use was for an educational purpose than if you put it in your commercial or you gained money from the use of this copyrighted work. So if you're using a copyrighted work because you want to take that work and you want to comment on it somehow, you want to say, here's what's right about it, here's what's wrong about it, you want to parody it, you want to make a criticism about it, it's something that's newsworthy that you want to comment on, that's going to be closer to the fair use side. And again, I can't give you a hard and fast rule here because there isn't one, but if you're going to take something and use it for its intended purpose, say you want to just take a song and put it on your YouTube video for fun because you like it and it sounds nice, that's the intended purpose of the music itself. So you're taking the market away from the copyright creator and using it for yourself. You're not commenting on it, you're not changing it in any way. It's not going to be considered fair use. So in those situations, you're going to want to get a license. And like I outlined before, the price of a copyright infringement lawsuit is so far and away more expensive than what it'll cost you to just get a license in the first place that you're better off just paying for a service that will give you a license for what you need, or using things in the public domain. Luckily, there are a ton of good websites on the internet for you to find works that are either public domain or have a broad license, or that you can pay for to get a license. So for graphics and photos, a few of those websites include Pixabay, Flat Icons, and a website called Pexels. Those websites aren't public domain content, it's actually content created by people who then give a broad license on the website for people to download and use however they want. And make sure when you are downloading something that the license is broad, that they say, yes, you can use this for commercial purposes, or yes, you can put this in your YouTube video, or however it lays it out, but make sure that you're getting the proper license because licenses can be different for different uses. You need different licenses. And then you also have Epidemic Sound, for example. I'm not sponsored by Epidemic Sound, though I would love to be. All the music you hear in all of my videos are from Epidemic Sound. They have a great selection. Some of their music is trash, but a lot of it is really good. It's $15 a month, which is so much less expensive than a copyright lawsuit. Pay the $15 a month or whatever you need to get the license that you need to properly use music, photos, videos, whatever in your YouTube videos or whatever else it is that you're creating. And last but not least, if you see something that someone has created and you want to incorporate it into something you're going to create, just get their permission. That can be as easy as just asking them, hey, can I use this in my YouTube video? Or hey, can I post this on my Instagram? You'll avoid a lot of conflict. As often as possible, always get things in writing because everything should always be in writing as a general rule of thumb. We should just be paying creators for the things they've created and then we can use them and we can all benefit. If you don't have the money up front to pay a creator for the things you want to use, maybe consider writing an agreement where you pay them a certain percentage of the money that you make off of what you're creating. That way they're benefiting, you're not stealing from anyone, and everyone feels warm and fuzzy. Because like I said, it can feel pretty shitty as a creator to see your work taken by someone else and used without permission. And not only that, but it could land you in a lot of trouble. So just be cool and ask the creator if you can use their work. So that's it for copyrights. Thank you so much for watching. If you have any other questions about this subject or anything else, please leave them in the comments below. I'm happy to answer. Check out this video here if you want to learn more about IP law generally, if you have a small business or if you're a creator. This is important. And this is a video that YouTube thinks you're going to really like. So check that out. Or click on my face if you want to see my profile or subscribe to me. Thanks so much. Have a good day. Goodbye.